My name is Dana Reeves. I am 49 years old. On the morning I sat across a conference table from the man who had spent 8 years telling everyone I was wrong, a federal prosecutor slid a single document toward me and asked if I recognized it. I looked at the date at the top. I looked at the case number. I looked at the signature line at the bottom where my name appeared in the handwriting I had used for 2 decades of reports filed in a department that no longer employed me. And then I looked up, past the prosecutor, past her paralegal, past the stack of binders, and I found Ray Hollister sitting 12 feet away with his attorney's hand pressed flat against the table between them, like a physical barrier someone thought might hold. He was 61 years old. He was wearing a tie I had never seen him wear when he ran a department. He was trying very hard not to look at me. I said, "Yes, I know this document. I wrote it on a Tuesday in October 8 years ago. He overturned it the following Friday. A man died because of that Friday. And everything that was going to happen in that room over the next 4 months began with my answer to that first question." I want you to understand something about the way this kind of work starts, because if you don't understand that part, you won't understand anything else. Fire investigation is not dramatic. It is not what you picture when you imagine someone who does it. You crawl, you kneel on concrete that is still warm through the knees of your coveralls. You smell things that will stay with you for the rest of your life. You learn to read a burn pattern the way a doctor reads an X-ray, the way a mechanic listens to an engine, and the reading is slow and quiet and almost entirely invisible to anyone standing next to you. Most people who watch you work think you are just looking at wreckage. They don't know that you are reading a story that the fire tried to destroy but couldn't quite finish. I came to it sideways. I spent the first 9 years of my career on a ladder company, fighting fires the way most people think of when they think of fighting fires. I went toward things other people were running away from. I pulled people out of places that were coming apart around me. I did that for 9 years and I was good at it, and I genuinely loved the particular clarity of it, the way a burning building reduces every decision to one question: what keeps someone alive right now? There is something almost restful about a problem that simple, even when everything around you is trying to kill you. But fire investigation is a different kind of problem. It asks what happened after the fire has already done what it came to do. It asks you to read backward. And when I transferred to the investigative unit in 2006, I found out I was very good at reading backward. My captain at the time was a man named Whitfield, who had been doing the work for 27 years and had a way of standing in a burned structure and going very quiet and very still until the place told him something. He taught me most of what I know about looking at origin points, about fuel load and ventilation patterns, about the specific geometry of a fire that was set versus a fire that started on its own. The difference is real and it is measurable, and it lives in details that most people would never notice. The depth of char at the origin point. The presence or absence of burn-throughs in flooring that suggest a fire burned longest where it started fastest. The location of the heaviest smoke damage in relation to the windows and doors. The particular way an accelerant will leave a pattern in the concrete subfloor after everything above it has burned away. Whitfield used to say that arson was the easiest crime in the world to commit and the hardest to prove, because the criminal destroys the evidence with the crime itself. He wasn't wrong. But he also used to say that nobody destroys everything. There is always something left. You just have to want to find it badly enough. I had been doing investigation work for 7 years when Ray Hollister became my captain in 2013. He had transferred from a district across town, and he came with a reputation as someone who moved fast and ran a clean shop and had no patience for people who complicated things. He was fine. I want to be honest about that, because the easy version of this story would make him a villain from the first page. And the truth is that for the first 2 years we worked together, he was unremarkable. He had opinions I disagreed with. He assigned priorities in ways I sometimes found frustrating. He had a tendency to close cases faster than I thought the evidence supported. None of that made him unusual. Departments run on caseloads and budgets and political relationships with building owners and insurance companies and city councils, and the pressure to close and move on is constant, and it comes from everywhere above you. I had learned to push back on that pressure in ways that kept me employed while still doing the work with the integrity it required. I thought I had figured out how to navigate it. I was wrong about that, but I didn't find out how wrong until October of 2015. The Eastview fire happened on a Wednesday morning in October. It was a commercial warehouse on the east side of the city, a building that had been sitting partially vacant for about 18 months after the tenant that occupied most of the space had moved out. The building was owned by a man named Gerald Crane, who had a portfolio of about 11 commercial properties across the city and who had filed 2 insurance claims in the previous 4 years, both on buildings that had experienced what were documented as electrical fires. I did not know about the previous claims when I first walked onto the Eastview site. I found them later, but I want you to note that detail because it matters. What I found at Eastview was not subtle. There was heavy char concentration in 2 distinct areas that were not connected to each other by any plausible path of natural fire spread. The burn was hottest in the northeast corner of the main floor and in a separate pattern near the loading dock entrance on the south wall. Between these 2 points, the fire had spread upward into the roof structure and then across, but the concrete subfloor between them showed a different burn pattern from the areas around the 2 origin points, which told me the spread had been assisted. The sprinkler system had been disabled. A partial review of the electrical panel showed no fault indicators that would explain ignition. The building's security camera system had been damaged, but the damage was localized to the equipment housing only and did not show the same kind of heat exposure you would expect from a fire that spread from another location. Someone had specifically addressed the camera equipment before the fire started. I also found the accelerant. It took me 3 visits and laboratory analysis of samples I pulled from the subfloor, but I found it. It was a petroleum distillate, consistent with a commercially available solvent, present in both origin areas at concentrations that could not be explained by any legitimate product that would have been stored in that section of the building. The building's inventory records, which I obtained from the previous tenant's storage manifest, showed no solvents of that type had ever been kept in those locations. I filed my report on a Tuesday. I identified the fire as incendiary in origin, meaning deliberately set. I documented the 2 origin points. I documented the accelerant findings. I documented the disabled sprinkler system and the targeted damage to the security equipment. I identified the building owner, Gerald Crane, as a person of interest based on the fire pattern, the property's financial context, which included a recent increase in insurance coverage from $900,000 to $1.4 million, executed approximately 4 months before the fire, and the 2 prior claims on his other properties. I recommended that the case be forwarded to the Arson unit for full investigation and that insurance payment be flagged pending outcome. By Thursday afternoon, Ray Hollister had called me into his office. He was not yelling. He was doing the version of unhappy that is quieter and more specific than yelling, the kind that lives in the way someone puts down a piece of paper. He put down my report and he looked at me and he said the evidence was inconclusive. He said I was reaching conclusions that the documentation didn't support. He said 2 origin points in a commercial warehouse were not automatically indicative of arson, that the sprinkler issue was likely a maintenance failure that had been documented previously, that the accelerant findings were preliminary and the lab analysis was still pending. He said that Gerald Crane was a well-regarded property owner who had cooperated fully with the initial examination and that I was building a case on a pattern that existed only in my interpretation of limited data. He told me to revise the report. I said no. I said the data supported the conclusions I had drawn, and I was not going to revise a report to say something I did not believe the evidence showed. He looked at me for a long moment, and then he said we could discuss it further after I had time to reconsider, and he dismissed me from the room. By Friday, the report had been overturned. Not revised, overturned. A memo went out from Hollister's office characterizing the Eastview fire as undetermined in origin, pending further review, with no evidence sufficient to support an incendiary finding. Gerald Crane was notified. The insurance claim moved forward. I want to tell you what that felt like, but I also want to be honest about the fact that feelings were not the primary problem in that moment. The primary problem was that I had filed a report that I knew was accurate, based on evidence I had collected and analyzed using methods I had spent 9 years developing, and that report had been dismissed without any competing analysis, without any independent examination, without any articulation of what specific element of my findings was incorrect. It was not overturned because someone looked at my evidence and found an error. It was overturned because someone above me had decided it was going to be overturned. What I did not know at the time was why. I assumed it was professional dismissal. I assumed it was the particular kind of institutional pressure that existed around large property owners with city relationships. I assumed, if I am being honest, that some part of it was the specific texture of being a woman in a department where the institutional memory ran back 40 years, and I was one of a small number of women who had ever held my position. I was used to having my judgments questioned in ways that felt different from how my male colleagues' judgments were questioned. I was used to being asked to justify findings that I did not think would have required justification if someone else had made them. I had navigated that for years. I was navigating it again. That was what I thought. I was wrong, but I didn't find out how wrong for a long time. What I did on the Friday the report was overturned was go home and make a copy of my original documentation. Every photograph, every lab analysis, every measurement and sample log, the full unrevised version of the report with my name and my findings exactly as I had written them. I saved a digital copy to a drive I kept at home, and I printed a hard copy and I put it in a folder in a filing cabinet in my home office. I have been asked many times since whether I knew at that moment that I was going to need that documentation. The honest answer is that I didn't know. I just could not make myself not keep it. It felt like the same instinct that makes you stop at an intersection and check both ways, even when you have the light. Something that had learned, without my specific awareness, to be careful. What happened in the months after that is a particular kind of slow erosion. It happens in departments, in workplaces, in families, in all the structures where someone decides to resist the pressure to change what they know to be true. And it is not dramatic and it is not sudden. It is the meeting you are not included in. It is the case assignment that goes to someone else. It is the way a conversation changes when you walk into the room. The particular quality of the silence that follows you, the way your supervisor finds reasons to redirect your work, the way colleagues who are not unkind people become people who do not quite meet your eyes. You are not fired. You are not formally reprimanded. You are moved to the outside edge of the room by 100 small adjustments that nobody would ever have to defend in an official proceeding. I brought the Eastview case up twice in the following 3 months, once in a department review meeting and once in a one-on-one with Hollister, where I presented the finalized lab analysis confirming the accelerant findings and asked that the case be reopened. Both times I was told the matter was closed. The second time, Hollister told me directly that continuing to press the issue was a problem for my position in the unit and that he was concerned about my professional judgment. That was November. In December, I had the back injury. It happened on a routine examination of a residential fire, a house fire in the Millfield district, that was a fairly straightforward electrical origin with no complicating factors. I was on the second floor, moving through a section of the structure that had been partially compromised, and a section of flooring gave way under me. I went through to the joists and caught myself with my arms before dropping the full story to the first floor. But the impact of stopping my own fall at that angle did something to my lower back that took 3 surgeries over the next 4 years to partially address, and that I will, the doctors have told me with careful honesty, simply manage for the rest of my life. Not fix. Manage. There's a difference, and you learn it. I was out for 4 months. When I came back, I was on restricted duty, which in an investigative unit is not as limiting as it sounds, but which my captain at that point made into something that functioned as a form of reassignment. The cases I was given were smaller, lower stakes, lower complexity, the kind that get resolved quickly with no controversy. I did them carefully and thoroughly because that is how I do any case, but I knew what was happening, and I think my captain knew that I knew, and neither of us said it aloud for another 6 months. I resigned in August of 2016. I filed the paperwork on a Monday morning and had coffee with Priya Nanda, who had been my closest colleague in the investigative unit for 4 years, who cried a little and told me I was making a mistake and then said, "No, you're not," in the same breath, because she was that kind of person. Priya had a way of being honest and warm at the same time that I have never quite been able to replicate. She brought me lunch 3 weeks after I left to my apartment and sat on my kitchen floor while I sorted through boxes and said things that were not about the job at all, just ordinary things, and that was what I needed. I did not tell her about the copy of the Eastview report in my filing cabinet. I did not tell anyone. My marriage to Marcus Webb had been failing for longer than I had acknowledged. He is not a bad man. I want to be clear about that. He is a man who had, over many years, constructed a version of me that made sense to him and which had become incompatible with the actual version of me that existed. The version that made sense to him was capable and dedicated, but ultimately deferential. Someone who would be frustrated by institutional obstacles, but who would ultimately accept the limits of what she could change. The actual version of me was not that. The Eastview case had made that gap undeniable. He thought I was obsessed with it. He said the word obsessed to me 4 times in the 8 months between the overturning of the report and my resignation, and each time he said it, something shifted between us that I did not know how to shift back. He thought my certainty about what I had found was a kind of rigidity. He thought my refusal to move on was harming our family. He was worried about my back, which was real and fair, and he was worried about what he called my perspective, which was not the right word for what he meant, but was the word he kept using. He meant he thought I had lost the ability to distinguish between what I could change and what I could not. He was telling me to let it go. I didn't, and so eventually he went. He was remarried within 2 years to a woman named Christine, who works in event coordination and who is pleasant in the specific way that pleasant becomes complicated when the person is raising your children. My daughter Lily was 9 when Marcus and I divorced, and my son Ethan was 6. They live primarily with Marcus and Christine. I see them every other weekend and on Wednesday evenings and at the specific events that require both parents and, which are therefore scheduled around the negotiation of what our mutual presence means and costs. I am good at my job. I am not always good at those negotiations. The school meeting was a Thursday evening in September, 2 years ago now. Lily was 17. The high school held parent information nights each fall, the kind where you sit in the gymnasium for 20 minutes, listening to the principal talk about the year's academic priorities, and then move through the hallway to brief sessions with the department heads. I had cleared my work calendar for it. I had driven 45 minutes from my apartment to the school. I wore a blazer because that is what I do when I need to feel prepared for something that I know is going to cost me something. And I had recognized by then that events involving Marcus and Christine usually cost me something. And I had learned to show up armored. I saw them near the entrance to the gymnasium, standing with another couple I didn't know. Marcus has always been good in rooms. He has an easy way with people, a genuinely warm social intelligence, the kind of sociability that I have never had and that I have never been sure whether I resent or simply observe. He saw me coming, and his expression did the thing it always does, which is to briefly calculate and then settle into a particular form of managed warmth, the warmth you show someone you have decided to be civil with and nothing more. He said Dana, with a smile, and Christine squeezed his arm, and then he turned to the other couple and said, "This is Dana," and he gestured between me and them in the way that was clearly going to include an explanation of who I was. He said she's Lily's mom. He said she was a firefighter in the department for a long time. And then he paused. And then he said, "Before," and then he smiled at the other couple in a way that closed the sentence. "Before," the couple nodded politely. I said it was nice to meet them. I said Lily was great, and I was excited to hear about the year. I found a seat in the gymnasium that was not near them. I sat through the principal's remarks and through the department meetings, and I drove home. And I sat in my car in my apartment building's parking garage for a while before I went inside, which is something I do sometimes when the evening has cost more than I had planned for, a kind of decompression in the transition space before I have to be inside myself in a room. Before, that was on a Thursday. On the following Saturday morning, I was at my kitchen table with my second coffee and the back section of the insurance risk analysis I had been working on for a commercial property portfolio when my phone rang. The caller identified herself as Special Agent Teresa Malik of the FBI's Financial Crimes Unit. She said she was investigating a fire that had occurred 6 weeks earlier at a commercial property on the west side of the city. She said the fire had resulted in 1 fatality. She said her investigation had a connection to a case that she believed I had worked on approximately 8 years ago. She said she would like to meet with me at my earliest convenience. She said, and I remember the specific phrase because it landed with a weight I did not expect. She said, "Your original documentation on the Eastview warehouse fire appears to be the only accurate account of that event that exists in any official record." I put down my coffee. I asked her what she meant by original documentation. She said she understood I might have retained a copy of a report that differed from the version entered into the department's official files. I did not ask her how she knew that. I said I would meet with her. We met at a diner 2 days later, a Tuesday, in a booth near the back where there was no one seated within easy hearing distance. Teresa Malik was 44 years old, precise and unhurried in the way that people who have been building cases for a long time tend to be. The patience of someone who has learned that rushing anything only makes it cost more time in the end. She had 2 cups of coffee and a folder that she kept closed for most of the first hour. She told me about the fire first. She told me about the building. She told me about the man who had died. His name was Edward Morrow, who went by Eddie. He was 53 years old. He had been the building superintendent for a commercial property on the west side of the city for 11 years, a property that was part of Gerald Crane's portfolio. 2 months before the fire, Eddie Morrow had agreed to cooperate with a federal investigation into an insurance fraud scheme involving Gerald Crane and several other property owners. He had agreed because his name appeared on maintenance records that he believed were falsified, and he had gone to a lawyer, and the lawyer had connected him to Teresa Malik's unit. He was not yet officially a protected witness. He was in a preliminary cooperation phase, what the federal system calls a proffer, a process of establishing what someone knows and whether it's useful. He had not yet signed anything. He had not yet testified. He had told the investigators what he knew, and he was waiting for the formal paperwork to be processed. And in the middle of that waiting period, the building where he lived and worked caught fire on a Sunday night, and he did not get out. I held that for a moment. I held it the way you hold information that you already knew somewhere in your body was coming, because I had been sitting with the shape of what had been possible since October 2015. And in some part of me that I had never articulated to anyone, I had understood that the thing I had warned about had happened, and that understanding did not make the specific weight of it any lighter. A name makes a loss specific in a way that abstracts do not. Eddie Morrow, 53 years old, 11 years in a building, someone who had decided to tell the truth and had not lived long enough to tell it under oath. Teresa Malik opened her folder. She walked me through what the federal investigation had assembled. Gerald Crane had been filing fraudulent insurance claims on his property portfolio for at least 11 years. The Eastview fire in 2015 was the 6th in the sequence, not the 3rd as the 2 prior claims I had been aware of suggested. There were 3 earlier fires on properties in other jurisdictions, each filed with different insurance carriers, each documented as accidental or undetermined, each closing with a payout that ranged between $600,000 and $1.1 million. The total amount Gerald Crane had received in fraudulent insurance payouts over the 11-year period was approximately $7.3 million. The insurance carriers who had paid out on the Eastview claim alone had paid $1.4 million on documentation that Crane's company had altered and that Hollister's overturning of my report had cleared the path. I said, how many of the fires were incendiary? She said, all of them. I asked her who in the other jurisdictions had worked the investigations. She named departments and dates. I did not know all of them, but I knew some. And I could see in the timeline the deliberate spread across jurisdictions, the rotation of carriers, the patience of a scheme that had learned to space itself carefully enough to avoid pattern recognition across any one agency's caseload. It was careful work. It was the work of someone who understood how investigation worked and knew how to stay beneath the threshold that triggered deeper examination. And in October 2015, someone who was doing that careful work had looked at my report and understood that I had crossed that threshold anyway, that I had seen what I was not supposed to see, and they had done something about it. She told me about Ray Hollister then. I want to describe what it is like to hear something that changes the frame of 8 years. It is not what most people expect. There is no dramatic emotional release, no sudden surge of vindication. What happens is quieter and stranger than that. What happens is a kind of slow recalibration, the way a room changes when someone turns on a lamp you hadn't noticed was there. The shapes don't change, but the light does, and you can suddenly see the corners you had been navigating by memory. I had believed, for 8 years, that Ray Hollister had overturned my report because he underestimated my work, because he was dismissive of my findings, because he had weighed the professional friction of backing an investigator against a well-connected property owner and found that friction not worth the cost. I had believed it was a failure of judgment and possibly a failure of character. but a human failure, the kind that emerges from the ordinary pressures of institutional leadership. I had not been naive about what institutions do to people who resist them. I had understood that I was being pushed out by a system that found my accuracy inconvenient. That was what I had understood. What Teresa Malik told me was that it was not inconvenience. It was a transaction. Gerald Crane's holding company had made payments to Ray Hollister beginning in 2014, the year before the Eastview fire. The payments were routed through a landscaping company that Hollister's brother-in-law had operated and which had received what were documented on paper as consulting fees. Over the course of 2 years, the payments totaled $42,000. The federal investigation had traced the money through 3 account transfers. The transaction was not sophisticated. It was the kind of arrangement that works, not because it's invisible, but because no one is looking. And no one is looking because no one has a reason to look. And no one has a reason to look, because the only accurate record of what was being paid to protect has been removed from the official files and replaced with a determination that says undetermined. Except that one copy still existed in my filing cabinet, printed on paper with my signature on the bottom line. I told her I had it. She already knew that, in the way that someone who has been building a case for several months tends to know things you haven't told them yet. She asked if I would be willing to provide it as evidence in the federal proceeding. I said yes. I asked her how long she had been building the case. She said 14 months. She said the Eastview documentation had been the missing piece. She said every other property in the sequence had closed in a way that left no competing record. Eastview was the one where an investigator had done her job correctly and then kept what she had. I went home after that meeting and I sat in my apartment for a while. I did not call Marcus. I did not call anyone. I sat with the specific weight of a particular kind of arithmetic. 8 years, 1 marriage, daily presence with my children, a career I had built for 21 years, a back that was never going to be what it was. Against those things, the thing I had kept. The folder in the filing cabinet, the document that was now the centerpiece of a federal fraud and murder investigation because I had, on a Friday 8 years ago, made a copy and put it in a drawer because something in me could not do otherwise. I have been asked what I felt in that moment, and I have tried to answer honestly each time, and the honest answer is that I did not feel vindicated. Vindication implies a joy that the arithmetic didn't support. What I felt was something older and quieter than that. I felt the specific kind of tired that comes when you have been carrying something for so long that putting it down and picking it up again costs about the same amount. What I did the next morning was call Priya. She answered on the second ring, which is how she always answers, as though she has been waiting to hear from you specifically. She was at her desk at the insurance firm where we had both worked for the past 6 years, our careers having followed a remarkably similar trajectory, from department investigative work into the quieter and considerably better compensated world of insurance consulting. She could tell from my voice that something had changed. She said, "What happened?" And I told her about the call from Teresa Malik and the meeting at the diner and the $42,000 and Eddie Morrow and what the federal case was about. She was quiet for longer than Priya is usually quiet. And then she said, "You kept it." I said, "I kept it." She said, "Dana, I want you to know I am furious on your behalf and also deeply unsurprised. And those two things are going to exist in me simultaneously for the foreseeable future." That was how Priya handled most things. She had a way of naming the contradiction and then living inside it without pretending it wasn't a contradiction, which is a skill I have always admired in her and never quite managed to develop for myself. The following weeks were the procedural work of a federal investigation, which means paperwork and meetings and more meetings and the particular exhaustion of being asked to tell the same story to multiple people with different pieces of the file who need to hear it from the beginning each time. I provided the original documentation. I provided the original lab analysis on the accelerant samples, which I had also kept because the samples were mine, and I had paid for the secondary analysis out of my own consultant's account after the department's analysis had been superseded by Hollister's determination. I sat through preliminary depositions and formal depositions and a briefing with the lead prosecutor, a woman named Aldana, who was precise and thorough and asked questions that made clear she had read everything and understood most of it and was checking the things she wasn't sure about. I answered every question as fully and accurately as I could. I did not embellish and I did not minimize. There were moments in that period that were difficult in ways I had not anticipated. The hardest one was not the deposition itself. The hardest one was a night about 3 weeks in, when I was reviewing my original documentation to prepare for the upcoming session, and I came across a note I had made in the margins of one of the site visit logs. The note said, "Possible secondary origin point near loading dock entrance. Confirm on third visit." And underneath that, in ink, from the same pen, from the same day, I had written, "This is arson." 2 words. This is arson. I had written them because that was what I knew. Because I had looked at the evidence with 23 years of experience and it had told me something specific and true, and I had written it down the way you write down the thing, in the middle of the process before the process tells you how to document it formally. Just the fact, in 2 words, as if someone might need to find it later, as if knowing that someone would need to find it later was already present in my hand as I wrote. I sat with that for a long time. I thought about Eddie Morrow. I thought about the specific nature of what he had done, which was to look at falsified records with his name on them and decide he was not going to live inside that lie. He had made a phone call. He had sat in a room with federal investigators and told them what he knew. He had been waiting for the formal protection to arrive when the fire came. I thought about the specific cruelty of that timing, the way the system that was supposed to protect him had been just a few weeks too slow. And I thought about what it means to be that close to the thing that will save you and not quite make it. I thought about his family. I did not know anything about his family, but I thought about them anyway, in the abstract, in the way that loss extends itself outward from the person who is lost into all the spaces they used to fill. And then I thought about my daughter Lily, who was 17 years old and who had spent most of her conscious life in a house where her mother's certainty about something she could not see or touch was one of the primary facts of her emotional landscape. I had never fully explained the Eastview case to her. She was 9 when I resigned, and then 11, and then 13, and now 17. And in all those years, the closest I had come to explaining was a conversation we had had the previous spring when she had asked me, not unkindly, but with the direct calibration of someone who is almost an adult and is done with soft edges, whether I regretted how things had gone at the department, whether I thought I should have handled it differently. I had thought about my answer for a moment, and then I had said, I handled it the way I knew how to handle it, given what was true, and I don't know how to regret that, even when it cost things. She had looked at me for a long moment with those eyes that are her father's and said, "Okay." In the particular tone that meant she was deciding how much she believed that. I hoped she believed it. I hoped she was old enough to understand it. I was 47 years old and I was still working on understanding it myself. I am going to tell you about the deposition itself because it is where everything that had been underground for 8 years came above ground and stood in the light and could be examined. The conference room was on the 14th floor of a federal building downtown. It was a gray October morning, raining, the kind of rain that comes sideways off the lake and makes everyone slightly worse at everything. Teresa Malik was there with the lead prosecutor, Aldana, and 2 members of the investigative team. Hollister was there with his attorney, a man named Garrett Oakes, who had the specific stillness of someone who has been in these rooms many times and has learned that stillness is its own kind of currency. There was a court reporter in the corner, and there was a video camera on a tripod, and there was a pitcher of water on the table that no one touched. When I walked in and found my seat, Hollister did not look at me immediately. He was looking at a point slightly to the right of the door, the way people look when they have decided to manage their attention carefully in a room that contains someone they would prefer not to have to see. I sat down. I looked at him directly. He eventually looked back, briefly, and then looked away. That was the only time we made anything resembling eye contact until Aldana put my original report on the table and asked me to confirm it. I had thought, on the drive downtown, about what I would feel when I saw him. I had thought I might feel something sharp, the specific heat of a long anger coming to a surface. What I felt instead was something much flatter and in some ways harder to describe. It was the feeling you have when a question you've been carrying for a very long time is about to be answered. The particular suspension of the moment before the answer arrives, when the question is still open but you can feel the shape of its closing. He was 61 years old and he was going to be a federal defendant, and the document that made him one was going to come across the table in my handwriting. That was happening. Nothing about being in the room made it more real than it had already become. The reality had arrived before I did. Aldana asked me to identify the document, I confirmed it was my original report, the version I had filed on a Tuesday in October 8 years ago, and which had been overturned the following Friday. She asked me to walk through the key findings. I walked through them. I described the two origin points, the accelerant analysis, the disabled sprinkler system, the targeted damage to the security equipment, the financial context of the insurance coverage increase, and the prior claims pattern I'd identified on Gerald Crane's other properties. I spoke without looking at my copy of the report for most of it, because I had never forgotten it, and because Hollister's attorney was watching me closely, and I wanted it to be clear that this was not a performance and not a preparation. It was memory. It was what I had known. Oakes cross-examined me for about 40 minutes. He was professional and measured, and he came at the documentation from 3 different angles, none of which landed the way he hoped. The metadata on the digital files held. The archived emails held. The chain of custody for the physical document was clean because I had kept it in one place for 8 years and had not touched it except to photograph it for my own records. He asked me whether I had any reason to believe that the department's official determination was incorrect beyond my own assessment of the evidence. I said yes. He asked me what reason. I said the evidence. He moved on. Ray Hollister's attorney, in the preliminary phases of the federal proceeding, attempted several approaches to discredit the original documentation I had provided. The argument that was floated most seriously was that the copy I had kept was a personal document outside the chain of official custody, and therefore its integrity could not be established. The federal prosecutors had anticipated this. They had cross-referenced the physical documentation I provided against the digital metadata of the files I had kept on the external drive, which showed creation dates and modification histories that matched the original filing timeline exactly. They had also located 3 emails I had sent from my department account in the 2 days before filing the official report, emails in which I had discussed preliminary findings with a colleague in the department's technical unit whose name appeared on the lab referral documentation. Those emails had been archived in the department's server system and had never been deleted because nobody had known they existed and therefore nobody had thought to delete them. The archived emails contained language that matched my original report closely enough to confirm that the document I had kept was what I said it was. This is a thing I want you to understand about the nature of truth in institutional settings. Truth does not disappear when institutions decide not to acknowledge it. It goes underground. It lives in archived emails and margin notes and hard copies in filing cabinets and in the memories of people who were there and who were paying attention. It survives in the specific texture of a document written by someone who was not trying to be believed later, but was simply trying to record what they had seen accurately. The fact that something is not in the official file does not mean it is not true. It means someone made a choice about what the official file would contain, and that choice can, if the conditions are right, be shown for what it was. Hollister pleaded guilty 3 months into the federal proceeding on a Friday in January. He pleaded to federal bribery charges and to obstruction of justice. He was 61 years old, and his attorney had clearly decided that a trial was not in his interest. I learned about the plea from Teresa Malik, who called me on a Saturday morning with the same unhurried precision she brought to everything. She said, "I wanted you to hear it from me before the news cycle picks it up." I said, "Thank you." There was a pause on the line. She said, "For the record, your report was accurate in every particular. Every single thing you identified in that document was confirmed by the Federal Investigation's independent analysis of the Eastview site conducted from archived photographic evidence and the contractor records we subpoenaed from Crane's holding company." I said, "I know." She said, "I know you know. I just wanted to say it on the record. Even if the record is just this phone call." Gerald Crane was convicted 6 weeks later on 12 counts of insurance fraud and 1 count of first-degree murder in connection with Eddie Morrow's death. The prosecution argued successfully that the fire at the West Side property was a deliberate act committed to silence a cooperating witness and that the pattern of prior incendiary events, of which Eastview was a documented example, established the intentional character of the conduct. The jury deliberated for 2 days. I was not in the courtroom when the verdict was read. I had testified in the weeks prior and had been released from any further obligation, and I was at my office when Teresa Malik sent me a text message that said simply, 12 counts. I sat with that for a while too. There is a particular kind of aftermath that nobody prepares you for. which is the specific quiet that follows the end of a long fight. People imagine vindication as something loud, something that arrives with a sound and a feeling and a clean replacement of what was lost. It isn't. What it is, in my experience, is a kind of readjustment. The weight you have been carrying reconfigures rather than disappears. What was fear and frustration and the specific exhaustion of fighting alone becomes something else, something lower in the body, something that sits differently. It doesn't hurt less, exactly. It becomes a different kind of hurt, and different is not nothing. Priya took me to dinner the week after Crane's conviction at a Vietnamese place near her apartment that she had been recommending for about 3 years and that I had never found the occasion to try. She ordered for both of us with the confidence of someone who has eaten there many times and knows exactly what matters on the menu. And she told me about a case she was working on, and I told her about a property assessment I had done the week before, and we talked about her daughter who was applying to universities and about the pain management clinic appointment I had rescheduled twice and finally attended. And it was an ordinary dinner between two people who know each other well and have weathered the same kinds of storms at different angles. She did not make a speech. She did not toast anything. At the end of the meal, she looked at me and said, "For the record, I never thought you were wrong, not for one day." I said, "I know." She said, "Do you though?" I said, "Yes." She said, "Good," and paid the check over my objection, which is what Priya does. I called Lily that night when I got home. It was later than I usually call, and she answered with the slightly guarded energy teenagers use when a parent calls at an unexpected time. I told her about the conviction. I told her in fairly simple terms what it meant, what had been proven, what had happened to the man who had overturned my report. She was quiet for a moment, and then she said, "So you were right." I said, "Yes." She said, "8 years ago, you were right." I said, "Yes." She said, "Dad thought you were obsessed with it." I said, "Yes." She said, "Were you?" I thought about that for a moment, and then I said, "No." I was paying attention to something that turned out to matter, and I held on to it because I didn't have anywhere to put it down. She was quiet again, and then she said, "I told Ethan you kept the report. He wants to read it." I said, "When he's ready." She said, "Okay." And then she said, "Mom?" I said, "Yeah." She said, "I'm glad you kept it." I said, "Me too, kid." There is a thing I have been asked about, which is whether I feel, looking back, that it was worth it. The marriage, the career, the 8 years of being someone other people used as an example of a cautionary tale about professional obstinacy. Whether I think it would have been possible to have done it differently and kept more of what I lost. I have thought about this question honestly, which means I have thought about it without the comforting simplification that the outcome now seems to offer. The outcome does not change the math of what the years cost. It changes the meaning of the math. And those are different things. What I know is that I did the job the way the job was supposed to be done. What I know is that I looked at evidence and I told the truth about what it showed. What I know is that on a Friday 8 years ago, when everything official around me had decided to say something different from what I had found, I made a copy of the truth and put it in a drawer. Not because I planned anything and not because I was certain anyone would ever want it, but because I could not make myself throw it away. Because some things you write down and some things you hold on to and some things you keep not because you know why, but because something in you has decided they matter. Eddie Morrow died because the first fire was not stopped. That is the fact. I cannot make easier with the outcome of the trial or the conviction of his killer or the guilty plea of the man who was paid to look the other way. That fact stands outside the legal resolution. It stands outside my vindication. It lives in its own column in the accounting, separate from everything else, and it costs what it costs, regardless of what happened in a federal courtroom. What I can say, and what I say when I am asked, is this. The report existed. I kept it. When the moment arrived that required it, it was there. I was there. Not triumphant, not unscathed, but there, in the room, with the document in my hands, ready to say, yes, I know this, I wrote it, this is what I found, this is what was true. That is all I did. I kept the record. I kept myself ready to speak to it. And eventually, when the room was finally ready to hear it, I spoke. I saw Marcus at Lily's fall recital a few months after the trial. She plays violin, and she is, I am told by people whose musical judgment I trust more than mine, genuinely excellent. He came in after I was seated and sat 3 rows ahead of me with Christine, and at the intermission, he turned and found me and walked back through the seats to where I was sitting. He stood at the end of my row and said, I heard about the conviction. And then he said, I should have trusted your judgment on that. He said it carefully, in the way that someone says something they have rehearsed and which costs them something to say. I looked at him for a moment. I said, yes, you should have. He nodded. He said, I'm sorry. I said, I know, and he went back to his seat. I don't know what to do with that apology exactly. I think it was sincere. I think he meant it in the full sense of what he was saying. I think it was years too late, and I think it was also, given who he is and what it cost him, something he needed to say and something I needed to hear. And I think those two things can both be true, and neither one resolves the other. That is the thing about long grief, which is what a marriage that fails over a question of integrity really is. It doesn't become something simpler because it ends. It becomes something you learn to carry differently. My back was worse than usual that day, from sitting in the auditorium seats, and I stood in the lobby during intermission and stretched against the wall in the way my physical therapist has taught me, which looks undignified and which I have long since stopped being embarrassed about. And Lily found me there and stood next to me and watched her father across the lobby without saying anything, and then said, You okay? And I said, yes. And she said, good. And she went back to find her string section friends, 17 years old and full of the particular restless energy of someone who is about to become something and knows it and can't quite wait for the arrival. I watched her go. I drove home after the recital on the highway, which is a 45-minute drive that I have made many times, and I listened to nothing because sometimes nothing is the right thing to listen to. And I thought about the filing cabinet in my home office that I would probably never need in that particular way again, but that I would never stop keeping careful records in, because that is simply what I do. And about the case I was working on at the time, which was a commercial property fire in another city that 2 insurance carriers were disputing the origin of, and which had several characteristics that I found interesting, and about Priya's dinner invitation for the following week, and about the pain management appointment I had actually kept this time, and the medication adjustment that seemed to be helping slightly, and about Lily's violin, which had been genuinely extraordinary. 45 minutes. My apartment building, my parking garage, my elevator, my kitchen table with the case files spread across it. I am 49 years old. I have a bad back from a floor collapse that happened in December of 2015. I have a filing cabinet in my home office that contains, among other things, the original documentation of an arson case from 8 years ago that a federal court has since confirmed I got exactly right. I drink too much coffee. I arrive at places slightly too early. I drive a truck that is 11 years old and which I have been told approximately 40 times I should replace, and which I am not going to replace because it runs well and I know its particular sounds and that knowledge has value. I have a daughter who plays violin and a son who wants to read an arson report and a colleague who pays the check without asking and calls on my worst days as though she somehow knows. I don't count the nights it cost me. That's not the job. What I count is what I kept, what I held, what I was ready to say when the room was finally ready to hear it. She didn't stop being right when they stopped listening. She just had to wait for the room that was finally willing to hear it. Being right, it turns out, doesn't expire. The evidence just needed somewhere to live until it was needed. And she had made sure it had a place.